Welcome to this edition of Thought to Action, presented by the Herb London Center for Policy Research. I'm your host, Chris Cordani. If you enjoy our content, don't forget to hit that like button. Also, comment, share, and subscribe. To enjoy sneak previews of our videos, exclusive content, and special programming, join our Patreon page, patreon.com/thought-to-action. You can also see our entire live stream sessions and Thought to Action's special Ask Us Anything videos. Also, follow us on Twitter, Facebook, LinkedIn, Getter, and our website, londoncenter.org. We also have a Teespring store with some cool merch. Check it out. You'll see the link in our description. The United States Supreme Court made two landmark constitutional decisions recently. The one which stole the headlines was the overturning of Roe v. Wade via Dobbs v. Jackson's Women's Health Organization's case. Before that, it was the ruling in the New York State Rifle and Pistol Association versus Bruin case, where New York's concealed carry legal hoops were overturned. These are strictly constitutional decisions, but became emotional. We're going to try to straighten some things out here. However, is this ushering a new era of constitutional originalism? We're going to talk to our panel about that. London Center for Policy Research President Lieutenant Colonel Tony Shaffer is with us, as well as London Center for Policy Research Distinguished Fellow, Navy Captain Pete O'Brien, London Center Board of Directors member Bennett McFadder, and London Center Senior Fellow Marine Captain Bill Heinzelman. Gentlemen, moving forward, as I had just asked, are we moving towards a new era of constitutional originalism with these decisions?
Yeah, okay, sure. And by the way, I want it noted, I'm wearing one of my Tom Fitton tight bicep shirts, just for everybody to look at. I'm just kind of styling it this morning. So just we're clear on that. So are we? I think the very nature of the Supreme Court is essentially trying to establish a return to basic principles. And I've watched with great interest. I was up till 3 a.m. last night watching the feedback from the liberal media on both decisions. And so they try to commingle the right of abortion and the right of the Second Amendment, which they're not. It doesn't exist. The Bill of Rights, to include the Second Amendment, was established in 1791 as part of the ratification of the Constitution. Some of you might remember there was the Articles of Confederation, then which didn't really work very well. The Confederation didn't work, so they had to go to a more direct form of republican governance with a federal system. And so, to protect individuals from overwhelming force that could come from the consolidation of great power at that level, the Bill of Rights was established. And one of those rights, an enumerated right, is the Second Amendment. It is a right. And so that was again clarified that to bear arms, that means you can bear arms in public. And I've always thought that was the intent of the founding fathers. And much of the Thomas decision, the verbiage that goes with the decision goes back to original intent, to the founding fathers. And it talks about their use of thinking, their use of the history of the Constitution as a foundation for going forward. So I think, to answer your question, Chris, yes, I think based on the very way the decision's written. In contrast to that is the whole idea that there was a right to abortion. There's no right to abortion. Anybody who reads the Constitution and the enumerated rights under the amendments to include the Bill of Rights, there's no such thing. And I think they have rightfully returned that issue to the states for a review by the people, and I think that's where, if there's ever going to be, and by the way, let me just say this is a political issue. The left always says this is decided law and everybody's for it. If that's so true, then call for a constitutional convention. There is a remedy, a political remedy to this issue. Call for a constitutional convention. It's listed in the Constitution as an option. Or if you can't do a constitutional convention for an amendment, then it should be easy, if everybody's for it, to have every member of the legislature of your own state go in and just establish it. Point being, it's not overwhelming. It's not something that every American is for. I can't believe any American is for total abortion of any baby at any time, but that's what the left wants. I don't know if you all knew this, 60% of all abortions at this point come from the day after pill. Great, wonderful. I don't think anybody's trying to get that taken away. Maybe a few extremists, but for those who follow this and actually look at the facts, more than 60% of all. So I don't know of anybody who wants to stop people using, essentially a pill to interfere with the process of gestation, of germination as an issue. Maybe I'm wrong, but to me, it's like, that's fine. Define that. But it's the heartbeat issue. That's what the Jackson issue was regarding Mississippi. So to me, one issue is an enumerated right, the Second Amendment, and one of the notable things, and I'll let my colleagues get into this because I don't want to bogart all the time. One of the reasons that they got as far as they did, because in the past, every court in America hates the Second Amendment. And so they've used something called intermediate scrutiny to actually look at all of these upcoming suits against government entities. And the Supreme Court basically said, no. You can't treat the Second Amendment as a secondary right. It's a primary right. It's enumerated, and you must use strict scrutiny. Strict scrutiny means you must actually look at and examine the impact on the individual of the diminution of that right. And there was a two-part test the state of New York was using to determine if you had the right to use your right to have a weapon. And the court said, no, you can't do that. You have to use it one test. And that was very clearly stated in the decision, and the decision to remove the restrictions. But strict scrutiny seems to be what the courts now want to use going forward. So this, again, answers Chris's question. Will this be something that the Supreme Court actually does in a different way? Yes, because they're saying now that any enumerated right has to go through strict scrutiny, which means that it really puts the onus on government to somehow prove that their forbearance of that right is in the interest of the country, that will allow them or would justify them to undermine individual rights, which I'd like to believe this is a good issue going forward. So there's my take on the two issues.
I'll chime in there, Chris, and I believe you're right, Tony, that we are seeing evidence of, a more originalist type of interpretation of the Constitution in the Supreme Court. But, with that said, it's not like this is some sort of plotted out execution and we've been, biding our time, waiting for our moment to strike. This thing with Roe v. Wade, and please somebody correct me if I'm wrong here, but it wasn't any Republican group or anything like that brought this up. It wasn't some sort of Christian group. It wasn't some religious group, some zealous group. It wasn't anything like that. This was in Mississippi, it was an abortion clinic who was challenging the law. And guess what? They lost. And that's why this is all happening, right? And so one of the big lies going around right now is that didn't happen. And that's exactly what happened. It was an abortion clinic trying to overturn the restriction of abortion after 15 weeks, and they lost. And to your point about Americans, what Americans want, what happened here is the Democratic Party, the Democrats went too far from center. They drifted too far left. And if we here generally reside somewhere in the middle, and I think about Elon Musk's little drawing of him ending up way farther right because of the way everything's drifting, right? And it pulls him from the center to the right. I think we're pretty much in the middle. If we keep drifting too far we're never going to get anything done. If we drift too far to the poles of these issues, we're never going to get anything done, and it's just going to keep being a divisive issue. Now, to my point, the Democrats drifting too far left. They overplayed what they thought the population wanted. They went for it and they were wrong. It was a miscalculation on their part. And now this is all coming back up again. So push it to the states. And then each state can figure out how they're going to manage and govern this, right? You're going to have 50 different solutions then. And we can all debate it and debate it and debate it. But to be torn apart at the federal level over this issue doesn't have to be the way it is anymore. So what Americans want, there was a poll done about a year ago, apparently, and the Democrats overplayed their position. They thought that Americans were going to go for this, overturning this ban. They thought that SCOTUS was going to go for it based on pressure from, the American populace. This is where they leaked this thing and, all of this nonsense going on. And they overplayed their position because the poll that was done about a year ago, the Democrats have shifted from the current position all the way to it should be a women's choice all the way up to the day of birth, like all the way up to that moment. And you should be able to decide to abort based on things like, the gender of your child, or just any reason at all. Your baby has Down syndrome, and so you can abort. But the reality is 70% of Americans are against that. They don't believe that that's right. And, when we talked about this the first time, I made a point about how it's not a binary debate. There's kind of three buckets for the Roe v. Wade thing. There's people that are against abortion altogether. There's people that, like I just said, they want to go all the way up to the day of birth for whatever reason. It's a woman's choice, all the way up till that first breath. And then there's everybody in between, which is why we need debate and why we need this to be pushed back down to the states so we can have multiple solutions and people can figure out what works best for them and go there, right? And that's the beauty of our republic. So on the Second Amendment, this one is going to right some wrongs. I mean, to say it plainly, there's not enough legal gun ownership in New York. I mean, my simple opinion, this is going to right a wrong for many Americans living in these places where they want to protect themselves and they can't. So simply put, now they're going to have an opportunity to legally gain access to firearms and protect themselves. And the biggest loss that I can foresee is going to happen to the Democratic Party's narrative of more guns equals more violence. What happens now when violence goes down? Because criminals are thinking twice about Good Samaritans packing everywhere they go.
That's a good
Criminals
question.
thinking twice about acting like criminals, and when there's good people carrying, and they can't know who's who.
That's a good question, Bill.
And on that point, before we get off that real quick, I watched Governor Holcomb. Is that her name? Holcomb?
Close enough. She's full of what you said. There we go.
Hodgepodge, whatever her name is. Anyway, she and the ladies from The View all talking about how individuals who basically aren't up to the elite level of being able to buy someone off, be able to pay some bribe or do something, they shouldn't have weapons. And this is what I found really ironic about the whole thing, to Bill's point, is that even though they know their policies don't work, they're now trying to figure out more infringement to interfere with the Supreme Court's decision, stipulations, restrictions on individual rights to bear arms. And I think it speaks volumes of the fact that they are the party of extremism. I'm speaking simply regarding what I believe the constitutional foundation is of the decision. And one party more than any other is now working either to use violence as political speech regarding the abortion issue, or in the case of the Second Amendment, more than willing to undermine the right of the individual in circumstances that they should be able to carry a weapon to protect themselves, are still stipulating facts that will eventually be law to prevent individuals from having open access to protect themselves. But to Bill's point, I think once you get people out with concealed weapons, it would change the fabric of the chaos in these large cities. But I would argue the left doesn't want that to be changed. They benefit from the fear and from the chaos. So
I'd like to make a couple of comments on that. I think we can take a step back and look at this from a legal perspective. And I think that actually both cases are related in this way. I think in this case, the Supreme Court acted apolitically, as they're supposed to. They're supposed to take an examination of, the Constitution and the jurisdiction to make certain laws. So if we look at Roe, which even RBG admitted was on shaky legal ground, there is no direct protected amendment there. To your point, Tony, if the people, right, we are governed, by and of the people. So if the people want to do that, there's a whole process for putting that in place. But for the Supreme Court originally in 1983 to come down and say it's a settled matter and therefore it's protected, actually truncated that discussion that should have been had at the time, right? It made it a protected federal right, capital R, right? And it did so improperly. I mean, the Supreme Court has overruled itself. There is stare decisis, but it's overruled itself over 100 times. I don't know what the exact number is. Obviously, Brown versus Board of Education is the most famous one. But, the Supreme Court has a duty. It has a duty to correct wrongs that have been made by previous incarnations of that court. So when you look at how they're related, I think number one, Supreme Court said, hey, look, we're not saying that you can't have an abortion. We're saying that there's no federal jurisdiction. There's no authority in law, right? Everything stems from all these documents built from the Magna Carta on up to our Constitution, Declaration of Independence, Constitution. Where in there do we have the jurisdiction to create a federal supremacy on this issue? That's very important. Where do we have the jurisdiction? And they said, rightfully, hey, look, we don't have it. So because we have a 10th Amendment, now it goes back to the states. And I think, it would be useful, maybe either in this this thought to action, or perhaps a future one, to talk about the details and the tough questions that the states are going to have to grapple with, right? To go through, a logic tree, what does all this mean? With respect to the Second Amendment, I'll conclude by saying it was also a victory for the rule of law because, right, while at the same time with Roe, they said, hey, we don't have the authority to do this at the federal level, so we're going to push it to the states. On the other hand, they said the Second Amendment, it's an enumerated right, right? What is that? What does an enumerated right actually mean? The Supreme Court in this ruling has been consistent, finally, with so many other rulings that they've had on First Amendment issues, Fourth Amendment issues, et cetera, where they've essentially said, look, all law has to conform and be subordinate to the Constitution. And because we have these things called rights, capital R, no law can effectively take something that is a right, convert it to a privilege, then issue a license to do that, and make it a crime if you don't have that license. So if you can imagine this, the First Amendment, what if somebody wanted to do that? Well, you got to send in a $200 tax stamp, ATF, right? Tax stamp. You got to send in a $200 tax stamp every time you want to say these certain things, this certain speech, this regulated speech. But you can do it, but we need, some money before you can do that. People would be outraged. And what they've said is, hey, look, the Second Amendment is right there. as a top level amendment. The strict scrutiny standard is a big deal also because, go back to jurisdiction, I'll conclude by saying that I think it might provide fertile ground for people to actually enforce their rights through litigation. So for me, for instance, if somebody was to come and say, now that the Supreme Court has made this clear, the state is going to come in, or the county's going to come in, or the city's going to come in and make all of these rights and make all these rules that are infringing on what now are the rights that are to be interpreted under the strict interpretation, right? Under strict interpretation. My question would be, where do you get the jurisdictional authority to do that? So that'll be worked out through litigation. But if it turns out you didn't have the authority to make that law, then guess what? That's a violation of my rights, not just Second Amendment,
Exactly.
the right to be let alone, right, in my person. There are damages associated with that. And because you should have known better, okay, as an attorney general, or whoever it is that's enforcing these or even making these laws, I think some courts may find that they were actually acting under color of law. And if these folks are acting under color of law, that makes them personally liable. So now we have this construct that from the top down has said, hey, look, this is strict scrutiny. This is a 100% top level right. So I think states and various other jurisdictions ought to think twice before they start making all of these contrary laws that are actually going to be infringing on people's rights, because they very well may open themselves up to heavy litigation, heavy damages, including personal liability in certain cases.
And there's an example that goes with what Bennett is saying that illustrates his 2 points. The Supreme Court correcting itself and then being super scrupulous regarding the strict review of law. And that is something else that the Democrats did. If you all recall, FDR interned Japanese American citizens.
And Italian
Sad,
Americans.
huh?
And Italian Americans.
Well,
Yes.
they deserved it. Just saying. I mean, but different story there. Just that's different.
Okay.
Well, anyway, the internment of American citizens, period. And guess who sustained it? Guess who originally said when it went through legal review, oh, it's okay. It's okay. The Supreme Court. So the Supreme Court went back and corrected itself, saying, well, maybe it's not such a good idea to intern American citizens. Maybe that really does go against the Constitution. But that illustrates what Bennett's saying. It's like initially they really made a boneheaded move. And then once the pizza shortage hit New York, they had to let all the Italians out, or else what are you going to do? What are you going to do?
Bennett, it's
Forget
also
about
funny.
it. Forget about it.
Exactly. No, forget
Yeah.
about it.
Forget about it.
If I can jump in.
I do want to add one more thing, Pete, because I want your take on this.
Okay.
Pete, I want your take on this, all right? Because, Bennett, you mentioned the Department of Justice. No sooner did these decisions come out with the Department of Justice, the Merrick Garland Department of Justice, denounced the 2 rulings. There's these people who are supposed to uphold the law and the Constitution denounced the constitutionally based decisions. Keep in mind, this, Pete, might show us what kind of bullet we dodged back in 2016. Remember, we could have had Garland on the Supreme Court.
Yeah, if I can, I would say simply this: that what needs to happen in the case of, and then I'll go back and talk about the other issue. But what needs to happen in the case of a department like the Department of Justice, simply ignoring its taskings and ignoring the law, is that Congress needs to harumph. And this is what I mean. But we have a set of rules that we have adopted over time that says that basically once Congress passes the budget, that they flick it over to the executive branch, and they never look at what's happening there. They only look at the next year of money. And technically, and that's by rule. That's not by, there's nothing in the Constitution that says that Congress can't interfere in the now year of what the executive branch is doing. There's nothing in the Constitution that says, my dog is upset, that the Congress has no role in current operations. Nothing says that. Congress passes the law. If the executive branch then goes and breaks the law today, there is nothing in the Constitution except a series of, there's nothing in Congress except a series of rules that they've accepted over time that says that Congress will not go back and simply strip that organization of its funding or specific authorities effective immediately. Now they would need to have veto authority, veto counts on their vote counts to be able to do that. But what really needs to happen here, and this is a much grander issue than the specifics, although the specifics of what Attorney General Garland are talking about are pretty egregious. Congress needs to assert itself and say, no, you do what we tell you, and you don't do what you want to do. And if you do, we're going to beat you about the head, neck, and shoulders. That's the real answer of what needs to happen there. And people will say, well, Democrats, Republicans. My answer is to go back and look. And I wish I could remember the specifics of it, but there was an incident in the Carter administration while Tip O'Neill was Speaker of the House. And I forget what the specifics were, but they did something that was not in the law. That was not the way the law was written. And like the day after it happened, Tip O'Neill went down to the White House and basically put his boot up the president's backside and said, "This is never going to happen again. And if it does, I'm gonna break my yardstick up your backside on this. You're not going to like this." And it ended. It ended right away. And Carter got the offending secretary, I forget again what the specifics were, back in line. And this reason why it was done had nothing to do with left or right politics, Democratic, Republican politics. It had to do with the president, the executive branch, was treading on the speaker's powers, and the speaker didn't put up with it. And that kind of tension in the system is needed, and it's missing. So I just throw that out there. And that needs to be done to Attorney General Garland, and it needs to be done hard, just to make him understand he doesn't make this up. He enforces the law. The law comes from Congress.
Well, Pete, a budgetary control, I think, is something that's overlooked and was overlooked completely by Trump, or at least on appearances. And that's one of the things that I think that our side, the rational side, the non-crazy side, has to examine regarding policy administration, is that there are specific policies established by Congress, and if in execution, if the executive branch in execution does not meet with that, it should be defunded, period. And I don't understand why it hasn't been done more. So
right, and it needs to be done hard, and it needs to be done fast. Right. Now, as far as the issue of both Roe v. Wade and the Second Amendment, I want to go back and touch on something that Bennett was talking about, and reset it one step further back from where he was. When the decision was made to not enumerate rights in the original draft of the Constitution, there was an argument. And the argument obviously had two major sides. One side was, we really need to enumerate rights because otherwise a future government will stomp all over them. The other side was, no, we don't want to enumerate rights, because if we enumerate rights, all the other rights, the ones that aren't enumerated, will in fact go away. Government will take them away. Now they came up with a solution for that. The solution were the 9th and 10th Amendments. The 9th and 10th Amendments basically said, if it's not here being the Constitution, it's not listed here, it is either owned by the people or it's owned by the states. It's not in limbo. It's not just out there. If it's not specifically here, it's either owned by the people or it's individually, or it's owned by the states, but it is not owned by the federal government. And so what is happening here is that ideas like abortion, and I'll give you a simple example that we have right here. I'm a strict believer in I'm opposed to abortion, and so the idea of the morning after pill, I don't think it should be defended. I think, but where should that be argued out? That should be argued out at the states. That should not be argued, that should not be decided by 9 people in black robes sitting secretly in a room, making a decision and passing it down from us like the fates passing down a decision out of Mount Olympus. That's not how a representative government works. You take these ideas, and they're sticky, confusing, messy ideas, and you throw them back into the states, and they're argued at the states, and they're argued again and again and again. And that the Commonwealth of Virginia may pass a law, and 2 years later, they may pass another law that cancels that first law and redefines the situation. That's what participatory government is all about. And that's what they just said. They flicked it back and said, if it's not an enumerated right, we absolutely don't have the role. That goes back to the states and to the people. And if it's enumerated right, it is an enumerated right. There's no such thing as a sort of enumerated right. There are simply enumerated rights, and there are other rights. Enumerated rights are enumerated rights, and you all have them. The unenumerated rights are decided at the states. And so what they did, philosophically, what they did was an absolutely essential issue to resolve that says participatory government requires participation. Go participate. Argue amongst yourselves. Settle this.
Yeah, I'd like to, I think that's right on point, Pete. I'd like to add a little bit to that. With respect to Congress and the power of Congress that they have, the remedy that Congress has in holding the purse strings, being able to impeach certain people, that's very powerful as part of our checks and balances. But the point that I want to add is that, as we talk about enumerated rights, you've got to think about enumerated rights for whom, right? And the answer is the individual. The individual right has to be the big dog. It has to be the big right, okay? And when, you talk about Merrick Garland and, if he does this and that, and, Congress should do something. Yes, I agree with that wholeheartedly, but let me give another example. If Merrick Garland was to come and, decide he didn't like the way I looked, and so he punched me in the head or hit me in the head, right? He would not be acting as an attorney general in that case. He couldn't say, hey, this is a little bit of a silly example, but I think it illustrates the point. He couldn't say, hey, look, I was allowed to do that because I'm the attorney general and hold a title out. Okay, the individual rights and the individual's ability to have recourse and remedy to protect those rights, recourse and remedy in litigation and damages, okay? To protect those rights is supreme to, any title in government. So he couldn't be protected there. I could say, no, somebody could say they're not going to prosecute him and they can, that's a whole different political discussion. But I can say, hey, I'm going to file a civil litigation. And he would not be protected in that case. He would not be able to go to the court and say, well, I punched him in the head, but I'm the attorney general, so I get to do what I want. No, there are damages. And when the damages come, if it's 100,000 or 100 million for punching me in the head, then guess what? He's responsible personally, because he cannot be clothed in that protection when he is clearly outside of his oath of office and outside of the protection that he clearly has in order to do his job. Now he needs the protection to do his job. But now let's go to the strict scrutiny. I think again, these people, whether it's the attorney general, Merrick Garland, whether it's a local mayor of a town or anybody in between, should really think long and hard about this strict scrutiny standard, because I really can see how anybody that has standing to file a civil litigation could go against anybody making laws contrary to the strict scrutiny standard and anybody seeking to enforce laws against that strict scrutiny standard as being not covered by their official title and having a personal liability for the violation of the rights. Again, our system only works if our individual rights are the big dog rights. They have to be the main rights. Consent of the governed, right? So yeah, we hire, some people or elect some people in Congress that we hope are going to do some things to help balance things out. maybe they do an impeachment, maybe the political winds change and something else happens. But for the protection of our individual rights, we should not have to wait for the political party to change, right? We should be able to go into a court and say, I've been damaged. Here's how I've been damaged. Here's what I claim the amount of damages to be. It doesn't matter if that person, man or woman, has a title. Well, yeah, their title is going to protect them if my claim is contrary to their lawful protections under that title. Okay, but if it's not, in line with the lawful protections under that title, I would ask if Merrick Garland, starts arresting people and if the Dems start ignoring the Supreme Court rulings, I would simply say, where do you get the authority, the jurisdictional authority to do what you're doing there? So I'm very bullish on jurisdiction. I think that's really what it's all about.
Before the decisions were made, there were gatherings, we'll just say gatherings, mostly peaceful gatherings, and I'm kidding, by the way, in front of the homes of Supreme Court justices. This was clear judicial intimidation, and to credit the ones that stuck by their guns and didn't turn around because of all this, I would have to say that's a good sign as well. Sometimes you worry about how politicians and judges might fold under circumstances like this, but I do want to say that the Supreme Court justices showed they would not back down against death threats, calls for violence, and the invasion of their own privacy at their homes, which, by the way, is illegal. At least duty superseded judicial intimidation.
Well, I think it's a great point, Chris, but it should never have come to that. So this is where, again, we talked about it here since the beginning of our Thought to Action series. The left has accepted as part of its fabric the use of violence as political speech. And somehow the media is completely in the bag, because I'm just going to say it, the 6th January events, while tragic and were violent, were nothing compared to Antifa and BLM that year before, where you had loss of life, billions in property damage, and wholesale racism against Black people. And this is one of those things, and this goes, I'm going to link this to the Second Amendment issue. Fundamentally, all of the tragic events regarding BLM and Antifa happened primarily in minority communities which were already underserved, whatever term you want to use, relating to the fact that they were not well off. They were poor communities. So you combine this violence with the pretending to say that we're for Black people, yet you're doing everything you can to essentially make life worse for Black people. That's racist. And the same thing with the gun issue regarding Second Amendment. As Bennett said and Pete said, and I think Bill talked about it a little bit, the moment you infringe on that Second Amendment right, you have violated that individual's constitutional right to have it. And one of the ways that's done is through expense. In New York, for example, to do all this, if you're rich, you can afford to put $5,000 down and get a gun. If you're living in Harlem and you're barely able to pay bills that relate to your basic living, and then the state says, oh yeah, you can have a gun, give us $5,000. That's a huge infringement. And I think it's racist, because in many of these places where these most severe gun restrictions and gun requirements and licensings are all done, it's meant to disenfranchise those who are poor, minorities to a great extent, from being armed, from exercising their right, which is something that again, the left completely ignores. The governor of New York getting up there and saying, oh, we don't believe that we think this is going to be more dangerous. More dangerous to who? Criminals who are openly flaunting your requirements for licensing, who openly violate every day the rights of other individuals by being armed and dangerous. Somehow you are promoting protecting them over individual citizens. That's what it comes down to. And that's what I find completely unacceptable regarding the left-wing progressive attitude regarding protecting people from guns. They do the opposite, and they simply do it, I think, in many ways because it's a racist policy that many on the left and the Democrat Party have always maintained from the end of the Civil War until now. They use different words and they use different techniques to do the same thing they did right after the Civil War to deprive minorities of the ability to protect themselves. So just saying.
If I could jump in there, I want to piggyback on what Tony just said. I would encourage people to go out and look at the numbers of for gun ownership in the cities of the United States that have the high crime rates: Chicago, Baltimore, Detroit, St. Louis, etc. And compare gun ownership rates in those cities to gun ownership rates across the country as a whole. Gun ownership rates across the country as a whole, there are over 400 million firearms in this country for 330 million people. And everybody who looks at that number seriously says we're probably seriously undercounting the number of firearms in this country. So you have 1.2, and it's probably closer to 2 guns for every person in the country. But when you go into a place like Baltimore, it's 3% of the population, or 2% of the population, 1% of some population, I think in New York City, have firearms. And so it is impossible to defend yourself. It is impossible for some poor woman on the south side of Chicago to go out and purchase a firearm to defend herself, defend her family in her house from some kind of gang violence. If you want to fix the problem, of gun violence in Chicago, my answer is every mom and dad there, give them a 9mm and 3 magazines. This is insanity. These people can't defend themselves, and there's a friggin' war zone going on outside their window.
Yeah, and by the way, if you had state-funded abortions, you ought to have state-funded ammunition drives and provisions,
Exactly.
since it's actually an enumerated right. And to Pete's point, next time someone talks to the governor of New York, someone should ask Governor Holcomb or whatever her name is, how many criminals have paid the proper licensing fee for the weapons they use? Just saying.
And how many of her bodyguards are carrying weapons?
Yeah.
Well,
Hey, think about the hypocrisy in this. We have Russians invading Ukraine. What do? Give them all kinds of munitions, give them arms, give them guns, give them javelins, give it to them, right? We got gangs invading our own cities at home. What do? Regulate them to the point where they can't afford to protect themselves. Mm-hmm. It's bonkers. It's bonkers. But I think people are getting smart. And I'm pretty sure I read something that Tim put out this year about the demographics of who's buying the most firearms. Like every year, the firearm sales increase, and there's always different demographics of who's buying up all the guns. And handguns are getting bought in record numbers by African American women. So people are starting to figure things out, and it's incredibly hopeful, I think.
If 1 or 2% of the people have the guns and they're causing all the problem in some of these cities, the good thing that tells me is that 98 or 99% of the people are intent on following the law. They're law-abiding citizens. They don't want to just go and get a gun illegally and risk becoming a felon. They need the law to support them. They actually need the law to support them. And with Tony's point, and actually you all three made the point, Tony, Bill, and Pete, about minorities in many cases, but certainly economically depressed areas where people cannot afford these licenses, or they even have trouble affording, the gun itself and the ammo and the ability to train up and things like that.
Right.
They're the ones that have the least ability to protect their rights, because litigation's expensive. You don't have enough pro bono lawyers to go out there and do that. But with these rulings, there's a cause of action called deprivation of rights under color of law. That's a cause of action. And again, I could definitely see, maybe some class action lawsuits that people can join for free, because when you talk about the damages, you see a little girl getting shot doing her homework, shot through the wall because these gangbangers are out there and unchecked. The police are disempowered, and I support police, but the police are disempowered. They're underfunded to go out there and do that stuff. If moms and dads, to Pete's point, were armed up, they would be able to do something about it. Gran Torino style or something maybe less Hollywood-esque. But if they are not easy targets, if there's not zero consequences for a gang member standing in the middle of the street doing whatever shooting he wants, and then being able to just walk away, okay, then maybe things will change there. So I'll conclude by saying something that Tim Wilson, one of our senior fellows, the Second Amendment says frequently: an armed society is a polite society. So if grandma could shoot back, maybe you're gonna treat her with a little bit more respect.
Or you're going to pick a different street to do what you're doing.
Right.
But one of Bennett's points, I think we need to recognize is important. Nobody is going to represent these people pro bono. As a matter of fact, even those who get paid get fired. Did you know that the two lawyers who actually won this case were fired from their law firm for their victory? Paul Clements and Aaron Murphy, Supreme Court litigators who won this case, who put it before the Supreme Court, were fired.
Well, they weren't fired. They were told they need to eject their clients, which of course is just.
And they went with the clients, yeah. So Chicago-based, that's a hint. Kirkland and Ellis decided to step back from gun control litigation.
That's one of the largest law firms in the country. That's not a small boutique firm. Kirkland is a very large. I hadn't heard that, Tony. But
yeah, it's in Politico. It's out. Yeah, it's official. So yeah.
They told these guys to dump their client.
That's right. Hey, I know you won. You did a great job to your clients, but F them.
It's almost like the firm wanted them to lose. And that sounds interesting too. I mean, I wonder what kind of support they were getting. Now, we don't have any proof. I'm not going to say I have any evidence that.
No, I think they thought they'd lose. I think they thought
that's what I'm guessing. I'm guessing that.
And by the way, tip of the hat to the two lawyers there. I forget their names, but tip of the hat. They left the law firm.
Clement and Murphy, the two lawyers, and they decided, what? We're going with the client. So
well done. God bless them. Well done to them.
They stuck with their ethics. That's what they're supposed to do. And unless the client was violating something major that actually under the ethics guidelines allows the lawyer to follow the client, it seems to me a bit unethical for the firm to tell the lawyers to fire their clients because of some sort of so there's a lot of issues there. But when a lawyer stops working for you zealously as the client, we've got problems. Our legal system breaks.
Is there an exception we can put into the abortion laws regarding lawyers and being able to go forward in time?
Well,
like
Iceland
time machine and then come back. It's like, yeah, it's okay.
Here's something interesting.
Lawyers.
Here's something that was brought up before: prenatal testing. If Iceland, I remember headlines. Was about a year or two ago, where Iceland was bragging about how they have such a low Down syndrome rate among babies.
Yeah, they went 2 years without any Down syndrome births or some extreme figure. Yeah,
they do the prenatal testing. So I'm not laughing at the prenatal, but they do the prenatal testing. I'm laughing at them bragging about it. And most of the pregnancies were terminated. Well, maybe that whole lawyer thing might have some merit there, Tony.
There's a gene. There's a gene in there somewhere.
For lawyers. That's right. It's like a 25th
track
chromosome.
That gene down. The lawyer gene.
That's terrible. Okay, I do want to.
As the lawyer, one of the lawyers there who was on the case pointed out, John Adams, as committed an American as ever there was, and of course vice president and then president, John Adams was the guy who defended the British soldiers in the Boston Massacre.
Right.
And the idea that someone could apply pressure to John, of course, that'd be humorous if you know anything about John Adams, but applying pressure to John Adams to get him to quit, it's just so horribly wrong. That whole idea. But that's part of what that law firm is suggesting.
Right. Well, part of this too, just to real quick, I know we got to go, but the technology issue is going to be something else that raises its head pretty quick. So I know that Holcomb, I gotta get her name down, basically said, oh, well, I'm all for returning to muskets. Like, the founding fathers, in writing the Second Amendment, fully knew the technology was going to change. It wasn't written for muskets. It was essentially the right of self-defense. One of the things that she tends to forget, apparently, is that during that time, big old swords were another weapon. As a matter of fact, up until, when was it, Pete? The Navy quit using swords for boarding other ships. Was it like 1980 or so? You guys finally give up swords? I'm just saying. I don't know.
Switched to
I
the
don't
carbine in the
sometime.
80s.
The
I don't
leftists,
know. 81? Was that when it was? No,
the leftists of the past will be saying,
I think Reagan got rid of them. Yeah, yeah.
the leftists of the
point-
past will be. The leftists of the past will be saying no American deserves or no American should have a claymore. It's too big.
I know. Well, my point being is that that the swords were in 1791 a valid weapon. It was a weapon. It wasn't just muskets. So the whole idea that somehow, oh, it's all about technology, it's not, because before too long we're going to have personal sized directed energy weapons, which you can literally melt someone's head. And it's not too far in the distance where those things are going to be available, because the technology's pretty much there. It's just a matter of someone figuring it out and putting these things together. So you can just go zap people. And I'm not joking about this. It's coming.
Governor, it's actually, I think it's Hochul, but
Hochul.
Hochul, Kathy Hochul.
Hochul.
But
It rhymes with yokel.
People need to remember with the Second Amendment. The Second Amendment was not meant for home defense or for going hunting. The Second Amendment was meant very specifically so that we, the people, who are the real country, the real government, the real authority, could, if there was a usurping leadership someplace in the government wanted to seize control and take power away from the people, the Second Amendment was there specifically so that such an individual and his followers could be put down by the people.
That's right.
That is the purpose of the Second Amendment.
So that's the purpose, Pete, that dovetails into exactly what Tony was saying. I was gonna lead to you, Bill, on this, being Marine Force Recon and looking at a lot of these weapons. Who are you defending? Who or what are you defending yourself against? And if you don't have at least equivalent weapons, firepower, whatever, weapons, format, whether it's, directed energy or whatever it is, if you don't have at least the same as your adversary, then you are at a distinct disadvantage in, defending yourself or defending your rights or, whatever the Second Amendment was intended for. So that right there, just basic logic has to tell you that, hey, it wasn't limited to muskets. It wasn't limited to deer hunting. So with that, Bill, do you have any thoughts on that?
Yeah, to me, this all boils down, and when we render both of these issues down all the way, for all these folks that are now, adults, the adults in the room, the world is on our watch now. It's time to figure out where you stand on these issues. Like you gotta search yourself and figure out where you stand on these issues. And one thing, when we render these two issues down all the way, it boils down to the simple question of, are we going to continue to be a body of self-governing individuals? Or are we going to depend on somebody else to govern us? Are we going to submit our liberty to someone else? And, I always stand on the other side. To me, it's like self-governing is the way to go. That's how our founders intended it to be. That's how it's supposed to be. And when I think about what our government has and what I don't have, and what I'm limited to, that scratches at me a little bit, because what if the day comes when our government gets blackmailed into forfeiting all of our liberties? What do we do then? I'll tell you, the first places that are going to get occupied will be the urban centers where there's no guns, where there are no legal guns, where there are no folks who've drawn all the lines in the sand around their souls and are gonna stand toe to toe until the moment of truth, right? But people want to. Both of these issues bring out so much emotion among our citizens, and they want to fight. And like, it's like, hey, what are you fighting for? Because if it's not a thing that you're willing to die for, you probably shouldn't be fighting, you know? And if it is, you better make sure you're ready to go take on that fight, right? And I think a lot of Americans really need to search their own souls and decide for themselves. All the adults, they need to decide now. Are you someone who can take care of yourself and take care of your family, or do you need someone else to take care of you? I'm in the first camp. I got a couple dependents. I got a handful of folks I'm going to take care of. I'm going to take care of my neighbors. I'm going to keep taking care of my community as best as I possibly can. And you know, to Pete's point about, I think Pete was talking about, you know, we talk about abortion. We talk about pushing it down to the states. I don't even like that. Like, I don't even like that. Like, this should be a discussion in a hospital room behind a closed door with nobody else except for me and, you know, a bleeding mother, and that's it, and a doctor, right? And their nurses, and like that's it. I got it. And folks need to really determine how much they're ready to forfeit over to an elected, an official. And
Yep.
Well, that's why you need to push back at the state levels. That's why we need that big.
Yeah.
The bottom line here with this discussion, the Supreme Court did its job. Not everybody's going to like it, but we should be thankful for it now and down the road.
Yeah, absolutely. I think your points are well made, Bill, but I think we're a long way from having to do, I'll say anything kinetic. I think the thing is, our remedy is in the law. It's in the law today. Most people just don't know it. When you say, well, what if the government took away our rights? You have to ask, okay, how are they going to do that exactly? Like, to actually take away our rights? They would have to pass laws. Those laws would then have the ability to be challenged, and then they go up through the courts, right? The role of the Supreme Court, is obviously not to make laws. We talk about judicial activism and things like that, but they have a very sacred role, a sacred role. That is the role of a trustee of the law, right?
Right.
They're supposed to be the trustees that, with wisdom, okay, and impartiality, look at the law and say, what does the law say? Why is the law so important? And the law, what's governed? Because the law represents what has been put on paper through the elected representative by the consent of the governed. So that's why it comes full circle. And people don't really get, little old me, you mean my rights are actually, the big dog rights? They're the actual capital R rights that all the other things come from. Probably 90% of the country, I don't think fundamentally understands that and really gets that. And that's why I think there's a lot of education that needs to happen, because once they understand that, that's empowering, and it empowers you to ask questions like, Mr. and Mrs. So-and-so, I'm ready to comply with the law, but let me ask you a question first. What gives you the right to do what you just did, or to take the action that you're proposing to take? Doesn't that violate the following rights of mine, right? Gives you the ability to do that, and then take it back through the courts. Hopefully, again, we need people that are committed with wisdom and proper judgment and humility on the courts. There's not enough of that. We talk about originality, and we started this off with that. It's this original intent. Here's the thing. If you have a contract, and that's really what the Constitution is, it's a contract among the people. It's a form of trust, public trust, that has trustees and beneficiaries. Some of the trustees we named, like the justices of the Supreme Court, and the beneficiaries are us. Each one of us individually is a beneficiary. Okay. But if you can, if Tony, I had a contract with you, and over the years following that contract, you could define terms to mean things different than we understood them to mean when we made the contract. What you can do is you can effectively steer the contract to mean anything you want. Okay. And that's the deception and the danger of our changing vocabulary, especially words of art, right? That are used by lawyers, right? Used in the courts, right? So looking at that, at what did those words mean at the time, and understanding that part of the assault on our individual freedoms and our capital R rights as individuals is the redefinition of terms, right? Making things mean something different today than they meant yesterday or 150 years ago, 200 years ago, is watering down what was intended at the time. So we have to be vigilant. I think there's a lot of education that has to happen there to help each individual American understand that they have a tremendous empowerment that they're probably not fully aware of, or if they are, they don't know exactly how to, enforce it. They've never heard of deprivation of rights under color of law or any such, action. And I think that's part of what our job should be, is to educate people on that.
I want to thank all of you for being with us for this special edition of Thought to Action presented by the Herb London Center for Policy Research. Please remember to hit that like button. Feel free to comment on our discussion. We appreciate your thoughts. And if you haven't already, please subscribe to our Thought to Action channel and pound the big red bell for updates on future shows. That's if you're watching YouTube. Hit the subscribe button on Rumble if that's where you're seeing us now. Find more about the London Center on our website, londoncenter.org. Also, check us out on Patreon, patreon.com/thought-to-action. If you subscribe to us, you can be privy to our Ask Us Anything sessions, full live streams, not just the clips you might see on YouTube. And you can also find some pretty cool stuff at our Teespring store. We have some merch, shirts, hats, everything else. Cool slogans, some new stuff coming soon. The link is in our descriptions. For our panel at the Herb London Center for Policy Research, I'm Chris Cordani. Thank you, everyone. Stay informed and make your day a great one.